The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to our Fostering Success Michigan Network webinar series. My name is Maddie Day and I am the Director of Outreach and Training with the Center for Fostering Success. Thank you so much for joining us today. This webinar series is focused on providing students, partners, and supportive adults with relevant information and resources related to the needs of students with experience in foster care. We would like to acknowledge our funders, the Kresge Foundation, the Havermill Foundation, and Western Michigan University for making this webinar possible. All of the resources that you will see in this webinar today will be available to you following the webinar. For those of you who registered early, you should have received an email that included links to our new guide, our new Fostering Success Michigan guide, Getting to Know Child Welfare for Educators. If you did not receive this email, don't worry. As I said, all of the resources, including the recording and the slide deck, will be made available through our FosteringSuccessMichigan.com website following this presentation. And now, today's webinar is Supporting Education Plans for Youth in Foster Care. What am I legally required to know? What can I do to help? By licensed Michigan attorney Elizabeth Bowker, who will be introduced by Carrie.
Elizabeth Bowker is a licensed attorney in the state of Michigan. She currently works at the Student Advocacy Center of Michigan as an educational advocate for DHS-involved youth. Elizabeth graduated from Michigan State Law School with a JD in 2009. She also has her master's from American Law School in Public Policy and her BA in Philosophy from the College of Worcester. Before joining Student Advocacy Center's team 4 years ago, Elizabeth worked as legislative assistant on the Hill in the District of Columbia and worked as a legal researcher for Bloomberg and Manhattan. Welcome, Elizabeth. Thank you for joining us.
Hello, thank you.
You can go ahead with your presentation. I'm hoping that there's not an echo on the slides. We're hearing a little bit of one, so hopefully our guests don't hear it. But thank you for presenting today.
Thank you very much for having me. So I will begin by just giving you all a general overview of what I do in my experience with foster care, students in foster care. I am an educational advocate for the Student Advocacy Center. I have been doing this for about 4 years. How our model works is that I have a referral process. There's a referral process from the Department of Human Services in Washtenaw County, and they will send me referrals to provide educational planning for students in foster care that are in need of either experiencing an educational crisis or in need of school enrollment or credit accrual or suspensions and expulsions. I can also get referrals through the GALs, and I work very closely with the schools, the Department of Human Services, and the court system. So it is a very interesting job to be in the crux of all three of those systems. On a national level, children in foster care are experiencing educational crisis that is receiving federal attention. There's been a lot of regulations and laws recently passed by the president and a lot of guidance to make sure that schools and foster care agencies, children welfare agencies work together in order to really combat a lot of these barriers that that foster care students are experiencing in the educational crisis. As a disclaimer, I have a lot of slides today, so I'm not going to read you the information on the slides. I'm confident that you can read the information, but it will be uploaded and you'll have access to all of the statistics and the laws that I cite on the PDF of the slides. So here's just listed some basic statistics regarding foster care that were They're pretty recent. They're from 2014. There's over about 400,000 students currently in foster care. The majority of those students are school-age students, and the majority of them typically experience an average of 2.8 living arrangements during the first year in care, and that's pretty typical. Every year of care, the student usually will face up to 1 to 3 different foster care living arrangements. They will, in that process of changing residences, they'll also change schools and middle schools within the middle of the year and during the summer. And the saddest statistic to me is that only 50% of foster youth graduate high school by the age of 18. And this is the lowest of any at-risk group that's ever been studied. They've done studies to try to break down different genders and different races within foster care to see if there's a disparity in race or gender, and that they haven't found any disparities so far. So it's really the foster care as a population are experiencing these great barriers. And it's up to the Department of Human Services and local schools to really combat this, figure out what's going on, and really tackle it so that we can save this whole population that's so vulnerable and really is struggling very much right now academically. And it's very sad because most of these students, when you first talk to them when they're younger, they all say they want to go to college, and they all say that they want to graduate high school, and such a small percentage actually do. So today in my PowerPoint, I'm just going to be explaining the laws that educators need to know, that they have a certain obligation to ensure the educational outcomes for this specific population. And it's been really a focus of the federal government. It's a really hot topic right now. I would say it's trending alongside with the population that are currently in juvenile detention centers and secured facilities, which can also, that population can overlap quite a bit. So in order to define a child in foster care, usually that is a foster youth who's a dependent or a ward of the juvenile court. They live in an out-of-home placement. There's a lot of different types of placements that foster care students can live in. They can live with a relative. They can live with a non-relative foster home, both in a family setting. They live in group homes. A lot of our youth is trending towards moving into residential and secured facilities, either because there's a lack of foster care placements in a family setting, or there are some behavioral issues that need to be addressed according to the child welfare agencies. There are also some youth who have a placement order and are considered foster youth, and that's through the Child Protective Service system. They aren't actually in out-of-home care, but they have done a Juvenile Criminal Act, and the court and CPS has become involved to ensure their stability at home so that they don't reoffend. And that's also a small population that I work with. I'll refer to those cases as JJ cases. They're also housed in DHS, and instead of having a probation officer, they actually have a DHS worker. And the services are very similar to the services that CPS involved and DHS foster care students receive. It's important for educators to know, however, that not all students who live in group homes or residential facilities are in foster care. I know there's some local shelters that are for runaway teens and for family situations that have gotten a little bit volatile, so they have to be removed from the home for a little bit, but that's on a voluntary basis, and their parents' rights are still terminated, and they are not being scrutinized by the state. There aren't any case plans in order or official capacity of DHS to work with those students. It's a difficult process to identify youth that are in foster care at your school, because it is not when I first started doing this job, I really thought that they would be, there would be class lists or something of that sort to identify to the educators of which students needed special supports or which students were entitled to certain rights under federal laws that protect the educational, give protections for within the education system for foster youth, but there really is no such list. The social service agencies aren't really working too closely with the school systems, as far as I can tell, to identify a student who's in foster care. A lot of times when I go to an IEP or I go to observe a student in a classroom, the teacher is surprised that the student is even in foster care and had no idea that they were going through a major transition in their life and had no idea that they could be considered homeless under the McKinney-Vento Act, and really just assumes that the aunt that they were living with or the non-relative foster parent was their biological parent. So some tips that I have that I've tried to, have teachers and administrators and counselors and secretaries. Secretaries are so great in identifying, and office assistants are so great in identifying this population. So I really stress to use them as a resource. But other strategies that I would suggest are to just use kind of an informal eyes and ears for red flags. If you hear, especially elementary students will speak about that they have visitation with their mom, or they have to go to DHS, or they had a worker said they couldn't see their dad anymore, or if their dad is incarcerated or mom's incarcerated or something of that nature. You can typically, if you have a trusting relationship with that student, you can talk to them about their living situation. Obviously in a private space, closed door, that's very important, and using basic questions that aren't too intrusive, just so that you can, and it's not to be nosy, it's just so that you can ensure that they are having school stability, being able to get to and from school, and that they are really taking advantage of a lot of protections that the federal government has tried to set up to help this population succeed. Another great relationship that I encourage everybody, all the educators to have, and also DHS workers to have, is a relationship with your McKinney-Vento homeless liaison. Every school district is required to have one, and they will typically flag students based on an enrollment residency verification form that's with the enrollment packets. Each district can implement their own. Ann Arbor, or the WISD, has a pretty simple one that just goes through the different definitions of homelessness, and if they check one off, then the homeless liaison has a private meeting with them in order to make sure that they know what their rights are and to see if they can help provide school clothing, food, information to housing opportunities, and those types of services. Also, I want to stress that to make sure to protect confidential information, really these conversations should be behind closed doors and with people who have the capacity to have an impact on the foster care child. It's not meant to be, a gossipy thing to try to figure out the family dynamics and family drama of these students. So just to protect confidential information, just to be very sensitive that the students may not want you to even know that they're in foster care. A lot of students at school, they'll introduce me as their aunt. Kids will ask me if I'm their mom, and I usually just say, oh yeah, or just kind of, do whatever they feel comfortable with, because it's really them leading their own feelings on it. And some students are really open about it, and other students, it's a very private thing. So that's also something to keep in mind. So under the McKinney-Vento Act, the McKinney-Vento Act requires that homeless students are identified by school personnel and through the coordination activities with other entities and agencies. And I'll get back to the relationship between students in foster care and the definition of homelessness by the McKinney-Vento Act, which is a federal act, but just in terms of identifying, there's some tips that can be used through that act to, just to encourage staff to attend McKinney-Vento trainings. They'll really go into more specifics of what red flags to look out for, and they'll give you the forms and assist you in identifying foster youth. You should also really avoid the use homeless for the purpose of asking your students about their living situation if they are in foster care, because a lot of times, even when students are really open about being in foster care and open about the struggles that they've been through, as soon as I say, oh, you qualify under homeless on the McKinney-Vento Act, they will surprisingly, or not so surprisingly, get pretty defensive and worked up about that. So I think that it's important for them to understand that that you aren't implying that they're homeless just because they're in foster care. It's just a federal definition to protect their rights. And also, it's important to know that not all foster youth are McKinney-Vento eligible, and we'll get into that later. This is just a chart I'm not going to go over it, but it's a really great chart that I use, and it states the role groups of each type of staff person administrator at the school and their connection to a homeless student and the type of trainings that they should do, and the types of red flags that they can pick up on. One example is for the cafeteria food service workers. If you consistently see a student who's not eating lunch, or asking peers for food, those hoarding food, those types of things might signify to you that there's not stable living environment that they go home to every night. Sorry, I'm kind of skipping my slides a little bit. So the child welfare system, just to go really quickly over it, just in case not all of you know completely about the procedures that enters a child into foster care. Basically what happens is that a CPS worker from DHS will file an initial complaint with the courts because they're concerned about the safety of the home, and they're suspecting abuse or neglect. In emergency situations, the law enforcement will come to the house and immediately remove the children. 60% of children enter care because of abuse and neglect. That's the most overwhelming population, and then there's a little bit of other statistics that are smaller groups, 5% running away, 10% enter because of the JJ cases that I was talking about earlier, and then the next biggest population under the abuse and neglect would be because their parents have passed away, they're in illness or on disability or other health reasons where they can't care for their children. The most important thing I think that educators should know is how to identify who plays what role in a child's plan when they are in foster care. It differs by state, but it's generally the same. The titles of the position may differ a little bit, but these are pretty consistent across all states. So basically, the person that you'll probably have the most contact with, or that will be most familiar to you, is the caseworker besides the foster parent. The foster parents usually are the ones that come to the school meetings. They are the ones that talk to the teachers about progress, will come pick up a child if the school calls for school disciplinary reasons. So really the foster parent is on the front lines. But because of a shortage of foster placements, unfortunately, we're seeing less and less foster parents, especially for high school students, and the caseworker will then act as the parent in those roles. The caseworker also creates the plan for the parents on how they can either reunify with their children, or if reunification is not the goal and the goal is adoption, they will also make efforts to find a permanent home. It's a pre-adoptive foster home for the child. They attend the court hearings. They report to the judge every 3 months. I go to the review hearings and report on the educational status of these youth. The DHS worker is there to answer basically the judge's questions and to make sure that that DHS is providing every opportunity to the parents in order to regain custody of their children, and also to the student in order to achieve their maximum, maximum ability and to be successful and to essentially to make sure that they're safe and happy and healthy and just like any other child. There's the judge, that goes without saying. The GAL is a attorney that is represented who is appointed that represents the best interest of the youth in care. The attorney will meet with the youth about once a month and will check up on the well-being of the student, if the student's healthy, if the student has medical needs, if they need clothes, if they are in danger in their foster placement, and they make their own recommendations at the end of the court hearing to determine, or recommendations to the judge so that they can determine if the student should return home to the biological parents, if the parents' rights should be terminated, or if the goal should change from reunification to adoption. And also a big role that the GALs are playing, especially with high school youth and unfortunately even as young as middle school youth, is they will monitor the staff interactions and the staff treatment of students that are in residentials and in group homes, and to make sure that they're safe there as well. Caseworkers and GALs, I think it's a good practice to always invite them to school meetings. They might not always come. I usually come in place of them, or if there's an educational advocate, they might come in place of them, but it's always a good practice to involve the GAL and the caseworker. The GAL specifically is a great person to involve if you have specific concerns that you want the court to order, such as you feel like the student really needs a medical evaluation, or you really feel that they aren't having proper winter clothes, or that something is not right in the foster home. The GAL can take that information and ask for court orders to ensure that the DHS is providing those necessary things in order to promote the health and the well-being of the child. The education planner advocate, that's what I do. I think our county is pretty unique that we have a private education planner, but typically I believe counties have, they'll utilize one education planner, I think, for every 3 counties, and all my work, I've never actually met an education planner. So I don't, I think that they do more work of reviewing files and ensuring that the transcripts are there, IEPs there, but I haven't seen them be very active on the front line, such as attending IEPs or expulsion hearings or those types of encounters where you would, go into dance recitals or school events or things like that. So I don't think that you'll probably interact with them that much. Then there's also or foster students usually have therapists, medical providers, and community health workers that are working with them. A wraparound coordinator is a specific caseworker that is referred from the Department of Human Services to ensure that all of the major caseworkers and stakeholders come to the table and wrap around their services around the child. Something that I've been pushing for recently, which has been really useful and successful, is to have the wraparound meetings actually at the school. It's more convenient for the student, and it's more convenient for the teachers, because then the teachers are able to join the meeting for 20-30 minutes to express concerns at school, and it's coming directly from the person who spends the most time with them. So it's been really beneficial. I've also been pushing for therapeutic services to happen at the school. I don't know if any of the educators that are listening have experienced foster care youth leaving in the middle of the day to go to medical appointments or evaluations, or a lot of absences are caused by, and they should be excused, but they're caused by court hearings, and visitation with parents can be scheduled in the middle of the day, and a lot of different services. So to have them come to the school is very beneficial to the student's education plan. I was already talking about this a little bit, so I'm going to kind of skip over this. I would say the only thing to mention here that I haven't really talked about is the semi-independent living. It's about 1% of foster care. Semi-independent living is where a student has shown a certain level of maturity, definitely not enough where I think most of us would think that they could live by themselves, but due to lack of foster care placements, they are able to move into apartments by themselves and basically care for themselves. They get a stipend from DHS instead of a foster parent getting a stipend, and it's really, that population is especially vulnerable to fall through the cracks because they have never lived on their own before, and they're living in pretty shoddy neighborhoods for the most of the part where rent is low, and it sounds really ideal to them at the time, but they are often the ones who suffer from electricity going off, from no groceries in their fridge, and really sad conditions. So if a student says that they're living in semi-independent living, well, it might sound nice that they have their own apartment. It's usually some of the most students that require the most support and supervision. Also, they start skipping school a lot and all of that stuff. So I have identified 8 barriers in education for youth in foster care, and I'm going to go through each of them pretty quickly and explain the laws, what's required of the educators in overcoming those barriers, and then what educators and administrators can do to go beyond, above and beyond, to really make an impact on these students' lives and to increase the rate of graduation, increase the rate of college access, and to really make a big impact on these students' lives. So the first law that I want to talk about is the Fostering Connections to Success and Increasing Adoption Act of 2008. Congress determined that children in foster care were entitled to educational stability and that the schools have a responsibility to ensure this. Now, the schools aren't actually the people that are held responsible technically under the law to ensure the provisions in this act, but it cannot work effectively and practically even if the schools don't provide the information and they don't act in collaboration with the state welfare agencies. The Fostering Connections to Success Act actually places the responsibility on the child welfare agencies, but as part of one of their responsibilities is to keep an education record as part of the written case plan. And that includes the information that I've listed below. So the Family Education Rights and Privacy Act, this is about sharing education between school administrators, school staff, and the child welfare agencies. Before, under the Federal Education Rights and Privacy Act, a parent's written permission was required to access any student's educational records, but they realized that they didn't really have foster care students in mind for this act. So in 2008, the Fostering Connections Act actually amended, made some exceptions to FERPA that allows agencies and child welfare agencies and schools to work more closely together to share information about the students. And the education records definition is very broad. So the Uninterrupted Scholars, it was the Uninterrupted Scholars Act that actually amended this. The Fostering Connections Act does have a part to play in this as well, but we'll get to that in a minute. The Uninterrupted Scholars Act was a huge deal. It was signed into law by President Obama in January 2013, and it amended FERPA in 2 major ways. As I said before, it allows the schools to release education records to agency caseworkers and other representatives of the state or local child welfare agency who is responsible for the child's care and protection without the written consent of a parent. Another way to do this, what I had to do before this act actually went into effect, is that I would always go to court and get court orders if I wasn't getting records from schools. So that way I didn't have to wait for the foster care worker to get the records from the schools and then wait for them to give it to me. I could just go to court, get a court order, I would scan it, send it to the school. Now it's made it so much easier that they aren't required to get a signed permission from the the foster care worker, and that instead that they can just, the foster care worker can request it on my behalf, and it can get sent directly to me. This again is just a federal letter to the state schools that's just really emphasizing that the Uninterrupted Scholars Act is going to really build a collaboration between schools and child welfare agencies, and they really encourage that the agencies share information about students in foster care to ensure the success of these students. The Uninterrupted Scholars Act also affects the confidentiality provisions under IDEA. It permits the disclosure of information for early interventions and education records of infants and toddlers, and also all the information regarding children with disabilities in foster care without written consent from the parents. So that's very nice too, to be able to have access without the written consent of the parent to the special education records. And this is just a mandate or an encouragement to continue to build interagency collaboration between educational agencies and child welfare. Some points to remember about the Uninterrupted Scholar Act are that schools are not required to disclose the records. This is just an act that says that they're allowed to and they're encouraged to, but it's not, they're not required to by law. FERPA and IDEA still require the schools to maintain their record-keeping requirements on anyone who requests access to the records, and they also have to document the actual disclosures of who they disclose the education records to, so that still all stays intact. Child welfare agencies can't redisclose information to the majority of individuals or agencies. They can only disclose it to people, redisclose it to people who have an impact on the child's education plan. The Uninterrupted Scholars Act still applies to children if they're, even if they're over 18, if they have an open foster care case. And it's very important for the schools and the child welfare agencies to use this act successfully for the judges, especially because when you go to court to have all the information in front of the judge can then determine if the school is the proper placement for that child, and if what's in the best interest for that child as far as if they need more intensive services therapeutically or a medication review, or you know, if they think that we should request an evaluation for special education. So it's really nice to have all the school records going into court. So the data that's typically requested by foster care workers, instead of saying child welfare agencies, I'm just not used to saying that, I'm going to say foster care workers. So I don't want that to trip you up, but you know, it's very broad, so they'll request education records, the general educations, grades, credits, earns, credits needed to graduate. A lot of times it's really helpful if the schools provide the foster care workers with the Power School or other comparable virtual login monitoring program for attendance and progress, because then we can monitor it every week to make sure that the student is turning in the work, and we can really help you to get the student the proper tutoring services, to see what's going on at home so that they can be successful in your class. All special education records, any school evaluations, psychological, speech and language. And I also like to request the teachers and the school administrators' information, contact information, and the IEP team members' contact information. Also, the homeless liaison is nice to request, and in cases of school disciplinary case situations, I will request the handbooks and code of conduct and all that. And this, I'm not going to go over this just because we have a lot to cover, but this is the different things that if you want to take a look back, that information that the foster care workers and DHS will share to the school administrations and staff. I've broken it down to these are things that are generally appropriate. It may be appropriate. They may you may be able to have access as educators to the relevant court orders and the contact information of the biological family, you know, mental and behavioral health issues that haven't manifested itself in school but are in the case file. You know, if there's a alcohol or substance abuse history and social history with law enforcement, those types of things. And it's never appropriate to inquire as to the specifics about the abuse and neglect history, or the fact if the child was adopted, or where the adoption is heading and where they are in that process, you know, DHS investigation details. Another thing that is inappropriate to ask for is students in foster care. There is I would say a fairly high number of students who have been involved in juvenile delinquent cases, but they've had their cases thrown out, or CSCs. We're seeing a lot of CSCs for consensual sexual acts within foster homes and on school grounds, actually. Those are getting picked up by the prosecutor, charged as CSCs, but there's a special diversion program that students can enroll in so that it doesn't go on their permanent record, and it's not appropriate for schools to ask about that. And also you can't ask about the foster family income. So this is just these are more tips for sharing student-specific education between local agencies and the ISDs. Basically, this will come into play when there is a student that it has to switch schools due to placement, because it's in the best interest of the student, whether determined by Mckinney-Vento school liaisons if they're Mckinney-Vento eligible, or the Child Welfare Agency if it's under the Fostering Connections Act. And what I wanted to stress is that the school staff of the previous, or the school last attended, or the school the students currently attended, should really reach out to the staff of the new school district to make sure that they have all the educational records that they need. I think it's really great when schools send me educational records. If they scan them and email them to me, I have them then, you know, saved on my computer. I can print them and access them whenever, and it's very fast. So when a student is out of school and needs to be enrolled immediately, it is very convenient to just be able to email a request over and have the school email it back or fax it back. They should, record offices, this is also a huge one. Please don't withhold transcripts or records for outstanding school materials, fees or fines, things like that, especially for students that you know are Mckinney-Vento eligible or in foster care, because it really, students are very mobile, and they go in and out of placements very rapidly at times and without a lot of warning. I've seen foster parents, you know, send their foster kids to school with a trash bag, and they don't have the time to get all their books, and they never see these people again. So they'll often lose books, they'll lose library books, and it's really frustrating when record offices won't give me the transcripts because there's fees or the degree. That's really frustrating as well. The special education staff should also communicate with the incoming special education staff. Just a quick call over to the special education office to determine what kind of placement the student is in, what the certification is, just to get the ball rolling before they have the actual IEP. And let's see. Oh, also I like to ask former teachers, school social workers, principals, anybody that really knew the student, just to type up a quick little narrative of strengths and weaknesses and interventions that worked and didn't work for all general education and special education students, just so that the incoming teacher has a little bit of a narrative on the student, knows the student a little bit more. Let's see. So this brings us to school enrollment. Delays in school enrollment often occur when a child enters into the foster placement initially and they need to change schools, or the subsequent change in placement and the living requirement requires that the child change schools again. They are usually delayed because the school is saying that they can't enroll because of partial or missing education records, the staff's not too familiar that, they might not be familiar that foster care placements, specific ones that we'll get to, are included in the homeless definition under the McKinney-Vento Act, which requires immediate enrollment. That sometimes they want legal citations on that. They also question sometimes the legality of myself or their foster care's grandmother going in and helping the student enroll in school, and they say that the guardian needs to be there, or they need guardianship papers or court orders and all of those things. This is the McKinney-Vento Act is also works in cooperation with the No Child Left Behind Act, and it's just to ensure the education in youth and homeless situations that they receive free and appropriate education. It really aims to remove obstacles that delay enrollment and to prevent residency requirements and mandatory documentation requirements and those things like that. In 2001, it was amended to make children who are awaiting foster care placement eligible as homeless. The McKinney-Vento Homeless Assistance Act of 2001, this is the change to the law, the child fine law, is that individuals who are awaiting foster care placement was included in the definition of the homeless definition, and they are entitled to all the same rights that a homeless or unaccompanied youth is entitled to. Awaiting foster care placement, there has been no federal regulations on what that means, so districts, local school agencies, and state agencies, school agencies, or education agencies, will, they come up with their own definition of what that means. In Washington, we just had an amendment. We used to be considered that all students who were in foster care, in a temporary foster care placement, were considering to be awaiting foster care and were entitled to McKinney-Vento services for that school year. They've now changed it that if there's 6 months stability in a foster care placement, the McKinney-Vento rights lift and they're not McKinney-Vento eligible anymore. So really look at your district to see what criteria they use in order to guide you to see if a student is waiting, should be considered to be McKinney-Vento under the awaiting foster care placement. In doubt, just go ahead and enroll without all of the education documents, because if they are considered to be eligible and you don't enroll, it's actually a violation of federal law. And there's been legislation, or I'm sorry, there has been some litigation surrounding schools violating these federal laws, and it's become actionable, and people are moving forward to rectify the breakdown of understanding and to correct the school's understanding that students who are awaiting foster care placement need to be immediately enrolled, even without any documentation. These are just some examples of, that's Ann Arbor's, I put ours up there. It's actually recently changed, but there's a couple other cities that, yes, and this is just the law that they should immediately enroll the homeless student, even if the student is unable to produce records normally required for enrollment, such as previous academic records, medical records, proof of residency, or other documentation. They don't even have to provide documentation that they're in foster care. Just their word for the time being. I mean, you obviously are going to follow up after they start school, and then you can take whatever remedies you need to in order to address false identification of McKinney-Vento rights, but you should err on the side of their word and immediately enroll them in school. These are just specific guidelines on the immediate enrollment requirements under the McKinney-Vento Act. The enrollment means that they have to be they can't just be enrolled in the school. They have to be attending classes and participating full activities. Immediate means no later than the beginning of the next school day after the presentment of enrollment. The presentment of enrollment is when the student or the guardian or somebody acting for the student comes to the school and attempts to enroll the child in the school. There are circumstances where you can wait until the beginning of the second day, the beginning of the third day for enrollment, but there's certain procedures that you have to follow in order to do such things. I'm going to skip ahead here a little bit, just to get to so the practice for facilitating school enrollments. I've listed all of the different tips and best practice guides that you can review and look over. There's things that I've based on research and just experience and different laws, and they seem to be helpful to me in my everyday practice. This is the School Transfer and Stability. The McKinney-Vento Act just determines who should be deciding if the student, when a student falls under the McKinney-Vento Act, they are entitled to stay at their school of origin in the school unless it's not in their best interest. And schools really, there's federal guidance that schools really need to make every effort that that child remains in the school that they were in when they changed placements. So unless it's really not in their best interest, they can't even consider transportation costs though. But you know, if a student has to drive 3 hours every day, that's probably not in their best interest. But they need to make every effort to keep the foster youth in the school of origin to the extent feasible. They also have the right to go to the local attendance school, which is the school where they're applying to, and if they do go there, enrollment needs to be immediate. This is just regarding determining the best interest under McKinney-Vento. It will be useful in deciding what factors to consider when you're making that decision. This is the Fostering Connections Act. This puts the responsibilities on the DHS worker and the child welfare workers. This applies to what they have to do in order to collect education information for case plans, and it basically is just the only obligation it really puts on the schools is to just be compliant and to help them collect the education in a speedy manner and to provide them access to school records. This is a great chart that shows who is McKinney-Vento eligible, who's Fostering Connections eligible, and then if there's an overlap. And these are, so I want to get to school discipline really quick, so I'm just kind of going over these. I know we're pressed for time. This is practices to ensure school stability, and I encourage you to review those. It's really important to maintain the school credits and to ensure that you are talking to your student and making sure that you're getting all the education records from high schools that they've attended. School transportation also falls under the McKinney-Vento and Fostering Success Acts. Fostering Success requires DHS to pay for it. Schools should really use Fostering Success. I haven't seen them use it as much as they should to get DHS to pay for transportation costs. And DHS is supposed to put transportation costs to school either directly in the foster care placement subsidy checks or directly to a transportation company. So just like McKinney-Vento, homeless liaisons have to set up transportation. All schools or DHS workers and child welfare agencies also have to set up transportation under the Fostering Connections Act. Those are just practices to remove transportation barriers. Special education barriers for foster youth. Some really quick things that I wanted to talk about is that it's very confusing. I know people get confused about it all the time, about the reauthorization and the amendments of IDEA to who can be a parent and who has the right to sign special education evaluations, to participate in the process of special education evaluations, and to be the education have educational rights. Basically, it has changed the definition so it includes foster parent, but in a nutshell, the schools must, and it included ward of the state too, but the schools must, in a nutshell, make every effort to ensure that the biological parents are involved in the process, regardless if the student is out of home. If these biological parents are acting, have taken affirmative action, or attempting to act on behalf of the child, then they are the ones that have the educational rights decision. If the school can't locate the biological parents, or the biological parents just aren't really interested, they don't really seem to care, then you move to the foster parents. They become the education decider. I used to think that it was the caseworker, but it's actually not. It's the foster parents, unless the judge appoints a somebody else to have educational rights, which they can, it's called a surrogate parent, and it has to be somebody that's not employed by DHS or the schools and knows the child. But it doesn't have to be by appointment. For the ward of the state, for me, I have educational rights. I just need the state agency to put it in letterhead and say that I have the rights, and then I do. And it's only for parental surrogacy under IDEA is only for special education decisions. Their rights don't have anything to do with anything else besides special education. The new amendments also added the ward of the state exception, where specifically addresses for students foster care, and that you don't have to, if there's a judge overseeing it, then they don't have to put on the court order that somebody's going to be the parental surrogate. They can just simply bring it up in a court hearing. They can decide it at a family team meeting, and there's a lot more leniency as to who can act for that. That's some special rules for the wards of the state. I really want to, I know we're so short on time, so I'm going to, outlines the role of the foster parents. This outlines the surrogate IDEA parents. The school's role in appointing surrogate parents. The school has the obligation to appoint surrogate parents if they cannot locate, if it's not a court ward, if they can't locate the parents and they've done the reasonable efforts, then they need to go through the process of recruiting an appropriate surrogate parent and screening them for conflict of interest. And schools actually appoint who the parent will be under IDEA, which is an interesting model, and I think it's pretty useful because the school probably knows who's most involved in the education of the student. So, just kind of skipping ahead here. IDEA also has a brand new emphasis on special education for foster youth. One thing to know that is that if you are pending an evaluation, there's a 60-day requirement, and if under federal, states can modify that, districts can modify that. But if one school district has started the special education evaluation process, and the student moves within that 60-day period, which happens frequently, the incoming school district is now responsible for that evaluation, and they are still mandated by that 60 days. So a student could come into the new school district with 10 days left on the evaluation, and the school still has to abide by that 10 days. Now, there's an exception that if they can prove that they are doing everything possible to ensure the complete evaluations and the parental surrogate agrees to it, then they can have an exception. But it's a pretty interesting law. The purpose of it is to ensure that education delays our education evaluations and certifications aren't delayed because the students in foster care have a really high mobility. Now, really quickly, these are transition plans, both IEPs and Fostering Connections Acts under their case service plan are both required to start implementing transitions in their plans, and it's really useful if they cooperate with each other so they can align the plans for the student aging out of care and aging out of the foster care system at the same time. And let's see. There are certain specific provisions in Fostering Connections Act IDEA and I believe the Uninterrupted Scholars Act that address residential settings, students that live in residential settings, and you still need to abide by all the same rules, basically the guidance on that you would for determining school placement. Let's see. These are tips to ensure special education barriers are lifted and school discipline. Okay, this is what I wanted to talk about very, very quickly. I know I only have 4 minutes. But students are being expelled and suspended for outrageous reasons. I think that there was a recent study that 90% of students that were being expelled or suspended were for nonviolent actions, and it was for disobedience or school dress or something like that. And there's really a huge push by the federal government and they just put out these new guidances for schools to get away from out-of-school suspensions and expulsions and to get away from this repeated requesting of this foster parent to pick up a student early from school, especially for students in foster care, because it really impacts their permanency ability and it really affects their whole life much more than school administrators intend to. So when a student gets expelled or suspended for a long term, we'll often see foster parents say, and reasonably so to some extent, that they don't have the resources to stay at home with the student all day, and so the student ends up typically going to a secure residential facility, institution, and they don't usually get out of that. Once that's on the student's record, it's very hard to find a foster care placement. So the effects and the impacts that it has on students that are in foster care to get these long-term out-of-school suspensions, they really need to be saved for really serious acts of school safety concerns. And instead, there's a lot of different guidances that the federal government just came out with to alternatives for discipline. This is just some of them, that exclusionary discipline should only be used as a last resort. You should reduce the number of suspensions, expulsions, and arrests by really putting in target supports. You should establish clear parameters and trainings for local police that are in schools. That's another problem that is popping up. There's a lot of police involvement in schools, and the roles and responsibilities are a little bit blurred. It's really important for school staff to understand trauma, how that affects students and their behavior. A lot of times what educators don't understand or they don't know, but if you just ask the student, or this is where the collaboration with the child welfare agencies, students have they have termination of the parental right hearings coming up. A lot of times they have to testify in sexual abuse cases. They have to have visitations with their biological parents that can be very stressful, or they found out that their foster parent just turned in the 30-day notice that they have to be out in 30 days, and it can really manifest itself in grumpiness, moodiness, irritability, putting their head down on the desk, putting earphones in, and just to be aware of the circumstances that are going around in that child's life, and to really understand that they're under immense amount of stress, and to not take personal, the personal name calling or the talking back, to take that too personal. And if a student has his head down or his headphones in, it really does the student no good in pushing them out of the classroom to go into the office or engaging in these combative fights with them that escalate to long-term suspensions. So it's having a national trend where these expulsions and long-term suspensions are directly pushing many of our teenage, it used to be just boys and now it's almost gender equal, 16 and above into behavior institutes, into secured settings, and it's creating a huge population of students that are housed in almost kind of like warehouses, and when they get out, it's not a good thing for the community, and they usually come back to the community that they were originally suspended or expelled from. So also one more quick thing in school discipline, and then I'll let you go. I know I'm running a little bit over, but another tactic to use is that when you are creating an IEP for a student, although their primary disability might be cognitively impaired or on the autism spectrum, it's very important to invite the psychologist or community mental health worker or to get a statement from them on other diagnoses that they have and put that in the IEP, so that if there is behavior that the student is displaying that is connected to, bipolar disorder or PTSD that is manifesting itself at school, in the MDR process, it can be addressed that way and put in interventions and make a great school climate and really address the needs of these children, instead of going forward and saying, oh, he's CI, this didn't have anything to do with his certification, because they can use whatever diagnosis is listed in the IEP. So that's something very helpful to remember for MDRs and behavior intervention plan meetings. There's so many different ways that you can really address behavior issues and trauma in schools without pushing them out.
So
let's see.
Elizabeth,
Yes.
This is Maddie, and we are a little bit over time, and I just wanted to say we can take a couple minutes. Those who are able to stay on a little bit later, if you have questions, feel free to send those questions in now. And Elizabeth, if you want to give your last kind of wrap up, last take home for this group, that would be great.
Oh, okay. My last subject actually was eliminating high school completion for barriers for youth in foster care, and something that I really want to stress is that because of the different types of placements that students go into, many of them with residential facilities especially, they award credits on a 0.25 scale or partial credits, or they load them up on peer resolution classes, a lot of classes that are not required under the Michigan curriculum. So it is very important that while you have these students stable in your school, to really take advantage of the stable environment that they're currently in, to load them up on credit recovery, to try to squeeze credits wherever you can, to keep them on track to graduate, and to just really make sure that, and always have the guidance counselors play a really important role, and always check in with them. I've listed a bunch of different things these are specifically for middle school guidance counselors, what they can do to help foster care students. And for high school guidance counselors, there's a bunch of tips, things that you can do to help foster care students gain the credits, have the confidence that they can graduate high school, and set them up for having a free college education, which they're entitled to in Michigan, and under a lot of federal laws too. So it's really, the world is their oyster in so many ways, so just to have adults supporting them can make a world of difference.
Great. Thank you so much. So it doesn't look like we have any questions. But I do want to scroll to this left side and just say thank you again to Elizabeth. This is her contact information. And if folks have questions, feel free to connect with her. One last thing I just want to know is we have another webinar coming up on Tuesday, March 17th from 2 to 3. This will be part of our Center for Success Best Practice Best Fit webinar series. And I am Maddie Day, again, will be discussing with my colleague Liz Brass the recently completed developmental evaluation of Fostering Success Michigan. Looking back to look forward. So thank you all again, and we hope you have a wonderful day.
Thank you, Maddie.
Thank you.